session, your queries will be answered by our speaker. Now, I request our speaker to commence today's session. Over to you, ma'am.
Thank you very much, Abhiruchi. And first of all, I must thank Honorable Justice K.D. Shahiji and the Principal Siddarth Law College, Dr. Sharafat Ali ji, who has invited me to share my views with the students of Siddarth Law College. And also, I'm thankful to all the organizing team, that is the faculty members, and the students must also be involved of the Siddarth Law College. So thank you very much for giving me the opportunity. As rightly told that I'm going to share my views on a topic which is relevant and contemporary for all the times to come for the human beings. You all must be aware that just 2 days back, we all were commemorating the Human Rights Day. So when we talk about the rights, we know that in simple words, these rights are said to be the common claims of the people, which every civilized society recognizes as the essential claims for their development, and which are therefore to be enforced by the state. So when we talk about the rights, then we see that these are known as the claims. And these are the things which are to be there in the civilized society. Civilized society has to recognize this. And these claims which are being demanded by the people, they are for their development. And at the same time, these claims are to be enforced by the state. So this is an important part, that the rights or the claims must be enforced by the state. Until and unless there is any enforceability of these rights, then there would be nothing of these rights, and that would not be considered as the rights. So in simple terms, what we know about the rights is that these are the claims which are to be there in the civilized society, and civilized society has to recognize that as the essential claims. And this is for the development of the common man, and these are to be enforced by the state. So the first thing which emerges out from this, rights definition, that is that it exists in a society. That is, rights always exist in a society, because these are the products of the social living. And when we say that the rights, then these are the recognized by the society for the common claims of the people. So I think that in simple terms, we must all be aware as to what are the rights and how it is being claimed in a society, and how the society has to enforce that rights for the benefit and development, for the improvement, for the advancement of the common man. Now, when we talk about the rights, then there are so many questions that may come to your mind. Is that sometimes you are listening that these are the natural rights, sometimes it is known as the human rights, as I just have spoken about, then legal rights, different types of the rights. So when we talk about the rights, you see that natural rights, those were the rights which are available to every person, every human being. And these are the rights, natural rights, which are independent of any act or statute. There is nothing like that these natural rights are the part of any act or statute. These are independent. They are the rights which are inalienable, natural rights. Then second types of the rights are known as the human rights. These are also inversely used as the natural rights, but these human rights are inalienable human rights. And you all must be aware that human rights have been those rights which are available to the human being by virtue of being born in the human race. That is, this is not something which has been conferred upon you. These are the rights which you all enjoy because you have taken birth in the human race. And we all know that the Universal Declaration of Human Rights of 1948, that is very important, that declared the rights, these human rights. And that document is mostly translated documents over 500 languages, you know. And the very purpose is that it must reach to every human being, because these are the inalienable rights. So human rights are of those category on the highest pedestal in the society. Then come the legal rights or statutory rights. When we talk about the legal rights or the statutory rights, then it is very clear from the terminology used for statutory rights that if there is a specific statute and that confers a right, then it is known as the statutory right or a legal right. For example, you may be aware of the Right to Information Act 2005. So under that right, the information right, that is known as the legal or the statutory right, that is there. Similarly, Consumer Protection Act, that confers the rights on the consumer. Right to education, that confers the right to education. So these are known as the statutory rights. Then there are another types of the rights which are known as the moral rights or ethical rights. So we live in a country which is having a very great cultural aspect and very great tradition of our society. So moral rights are always very important for we Indians. And these moral rights are sometimes we see that these are codified, sometimes it is not codified even, then still we have to follow. For example, to take care of the parents, that's a moral right of every children. But we have the Senior Citizen Act also, because of the changing in the society, these moral rights were not being followed by the children, and that's why the parliament has to come with the enactment or codification of these rights. Similarly, you see the copyright, that is also having certain parts which are said to be the moral rights. Then ethical rights are also one of the rights, and we see that these ethics are to be involved in each one of us, and we have to follow those ethics. But when we are talking about the ethics in academia, we see, or in educational system, so every time we see that the persons who are writing research papers, who are doing PhDs, they are just following unfair means, they are just copying from the other. Copyright Act is there, but at the same time the ethical principles are not being followed, and you just copied everything without recognizing the person whose work you are taking about. So there is some plagiarism rules also which are related to this ethical rights. Then there are civil rights. We see that a right to vote in a democracy like India, we have a right to vote, that is our civil right. And political right is also one of the right which is related to the civil right. If you want to contest the election, this is your political right, you can go for that. Then economic rights and business rights are also there. And then there is constitutional rights. When we talk about the constitutional rights, then all those rights which are different from what is given under part 3rd of the constitution, those are known as the constitutional rights. For example, under article 301, if we see, then it speaks about the trade and commerce. So that is the trade, commerce, and that should be free throughout the territory of India. 301 speaks about that. So this trade and commerce is a constitutional right. Similarly, 300A, that speaks about the property. So that's a constitutional right, right to property, which has been amended in by 44th amendment. Earlier it was a fundamental right, but later on it has become only a constitutional right. So constitutional rights are different. And then comes the most sacrosanct and the most important and the most significant rights. Those are known as the fundamental rights. So we know that the constitution, that is the largest constitution, the biggest constitution, written constitution of India, and that is consisting of the fundamental rights in part 3rd of the constitution, and that part 3rd is having article 12 to article 35. So there we know that the fundamental rights have been given to every citizen and the person, as the case may be. So when we reach this for fundamental rights, we have to go back to see the history as to how these fundamental rights have become the part of our constitution. So historically, we look back, then we see that the year 1215, and that was the landmark year. And that was the year when the Magna Carta, which we see that begins with the concept of the human rights, that the man has certain essential basic rights, certain natural rights, or unavoidable or inalienable rights and freedoms. That was the content of this Magna Carta of 1215. So historically, we see that after natural rights, these were the codified rights in the existence of the human history. And with the natural theories like Hobbes theory or Locke's theory, which speaks about the social contract system. So it was thought that this is the function of the state to protect the life of the person, the liberty, the property of every individual. But we see that with the operation of the state, this concept which was granted, that the protection against the state, that it is not under coming under the social contract theory, but now if you are having the rights, then these rights are to be protected against the state, so that state may not interfere in the rights of the person concerned. And we see that some of the written constitutions that guaranteed certain rights, and they forbid the governmental organs from violating them. There is a clear provision in many of the constitutions. I'll be talking about our constitution also. So these are the rights which are characterized as the fundamental rights, because they confer the justiciability, and they impose the restrictions and limitations on the governmental actions. So during the time when the Indians were struggling for the independence, and we see that in India, the Swaraj Bill of 1895, that was inspired by Lokmanya Bal Gangadhar Tilak, that visualized a constitution that can grant to every citizen rights. And the rights which are so basic as freedom of expression, equality before the law, then right to property. So these type of the rights were visualized in this Swaraj Bill of Lokmanya Bal Gangadhar Tilak. That was in 1895. Then after that, we see that Mrs. Annie Besant, she brought this Commonwealth of India Bill, and that also enumerated the fundamental rights. And the bill of Mrs. Annie Besant, that was almost identical in its scope. And that was having the similar nature also as was given by Swaraj Bill of Lokmanya Bal Gangadhar Tilak. So this was related to the bill, to the enumerated rights, fundamental rights, and it has also the similarity with this Irish Free State Constitution of 1921. So we find that in 1895 the Swaraj Bill came. Then in 1920, and then after that the bill of Mrs. Annie Besant, Commonwealth of India Bill, that came. That was having the similarity of 1929 Irish Free State of the Constitution Bill. Then Indian National Congress, that also passed a resolution in 1927 at Madras. And we see that this Indian National Congress, that resolution that declared the basis of the future constitution of India, that must be having a declaration on the fundamental rights for the citizens. So we see that when this second roundtable conference was held in 1931, then British Prime Minister MacDonald announced that he was in favor of incorporating a list of the fundamental rights, and he proposed that it should be there in the federal constitution of India for safeguarding the interest of the Indians. But you see that this demand of the Indians was ridiculed, and it was not accepted, and it was refused, it was rejected by Simon Commission. And the reason which was given by that commission was that we just don't want to give you the abstract declarations which cannot be made effective, which cannot be enforced, which cannot be, applicable. So these abstract declarations will be of no use. Hence, there is no need of fundamental rights. So you see that after that, when the Government of India Act 1935 came in, then there was no provision of any of the fundamental rights. Then when the constitution was started to be drafted, then the authors of the Indian constitution, they were all influenced by the Declaration of American Independence of 1776 that was drafted by Jefferson. And at the same time, there was a US Constitution of 1787, which was enforced in 1789. So one of the important thing about the US Constitution is that the Constitution, which was originally enforced in 1789, there was nothing like any of the rights. And it was only 2 years after, that is in 1791, that 10 amendments have been made in the US Constitution, and these first 10 amendments are known as the Bill of Rights. So the Bill of Rights in the US Constitution 1791 were the first 10 amendments, which speaks of various rights. Then at the same time, the founding fathers of the Constitution in India, they were also having some influence of the French Declaration of the Rights of Men, and the Universal Declaration of Human Rights also, which was adopted by the United Nations, and many more constitutions of the world which were in existence at that time. At the time of the drafting of the Constitution, you see that these were having the impact on the Constitution writing at that time when the Constitution of India was being drafted, because the constitutional advisor, Sir V.N. Rao, he has provided the material of various constitutions of the world, and the authors of the Constitution, they have all gone through that, and particularly the subcommittees on the fundamental rights, they have prepared a big draft on the fundamental rights so as to put in the Constitution, because every time there was a demand for the rights, demand for the liberty, demands for these claims, which could be enforced and which could be made available to every citizen in the free India, in the independent India. So the authors were very much influenced to give the part, this part third in the Constitution, that is fundamental rights. So in a way, we see that this document, this Indian Constitution, is of eclectic nature. When we talk about the eclectic nature, that means that our is a constitution which has derived ideas, style, and taste from various or other sources. There is a broad range of source, or broad range or diverse range, we can say, of sources which has been incorporated in our constitution. So this is how we see that the eclectic nature of our constitution, and that is very important, because nothing has been left. And that's why I told you that ours is a constitution which is the biggest, largest written constitution. Even American Constitution is consisting of only and only 7 articles. So we see that we have very distinctive features of fundamental rights in the Constitution, because when we compare the fundamental rights in the England or in US, then the position of fundamental rights is different than in India. In India, we find that a compromise between the doctrine of parliamentary supremacy that exists in England, or the judicial supremacy that exists in the US. In our country, the Parliament of India is created and limited by the written Constitution, which enables the state to legislate subject to limitations, subject to prohibitions imposed within the Constitution itself. So Parliament is not free to enact any law that is there in the provision of the Constitution. I'll be talking on Article 13 also in this respect. Then there are provisions such as the distribution of legislative powers. You see that the Parliament can enact those laws which are there in the Schedule 7 List 1 and the concurrent list 3. So there is also certain limitation or prohibition which have been imposed by the Constitution itself. So in India, we see that the provision regarding fundamental rights, the provision regarding the use of different types of the rights is different from that of the other countries like US and UK. So we see that the declaration of the US Bill of Rights, that is absolute, and there is no restriction. But when the US Constitution was adopted and when it started in exercise, implementation has been there, then we find that there must be some of the restrictions, and then we see that the judiciary there developed certain restrictions, but we have the restrictions written in the Constitution itself. Then one of the important provision in the American Constitution, that is regarding 9th Amendment, that is speaking about the unenumerated rights. That simply means that unenumerated rights are those rights which are not mentioned in the Constitution. And this 9th Amendment is very important for the purpose of American Constitution, which says that enumeration in the Constitution of certain rights shall not be construed to deny or to disparage the others retained by the people. The rights which are there in first to 8 amendments which have been written over there, those rights should not be construed so as to give the unenumeration of that right. And you see that by these unenumerated rights, the US Supreme Court has also incorporated other rights like right to association, right to go abroad, right to privacy. So various things were there. But when we see the US Supreme Court, that has referred, or we can say they have relied more on a broad interpretation of the rights which were already enumerated rights. That is, they have not given very, largest interpretation to the unenumerated right, as in contrast with the Indian Constitution and what the judiciary is doing in India. So when we talk about the US Supreme Court, that has restored to the theory of new rights are more in nature of penumbra. So when we talk about the penumbra, then it simply means that the US constitutional law, that penumbra includes a group of rights which have been derived or by implication from the other rights which are explicitly protected by the Bill of Rights. So the US Constitution says that this nature of penumbra form the emanation from the rights which have been expressly granted to the person, to the citizens there. And so the Ninth Amendment has not formed the real basis for the additions of, we can say, mid or more of the unenumerated rights. And that's why we see that Indian Constitution, though it does not have anything like the Ninth Amendment of US Constitution, but the Supreme Court in post Maneka Gandhi case, that has been taken a very, very activist view of its function. And you see that part fourth of the Constitution, that is directive principles of the state policy, and that is proving to be very, very rich reservoir of ideas. That is also giving an eligible list of interests that has to be translated into rights of variable importance, magnitude, and you can say it can be construed enormously. And the right to life under Article 21 has become a vessel of immense capacity to accept all these translations into its fold. And there was one decision of the Supreme Court in 2003, PUCL versus Union of India, that is People's United for Civil Liberties, where the Supreme Court said that fundamental rights were once described by the Supreme Court as empty vessels into which each generation must pour its content in the light of its experience. That, you see, this Article 21 has been interpreted so exhaustively that it is including many of the rights within its encompass. And it is just like the empty vessel, and every generation, not only every generation, but each bench of the Supreme Court and the High Court, they are pouring their experience just in order to give a wider interpretation of Article 21, which includes life and personal liberty. So constitutionally speaking, this creative interpretation can be made in two ways, which is very, very important. One, it is possible that the language of the provision itself may be very broadly worded. We can take the example of Article 19(1)(a). You know that Article 19(1)(a) guarantees the freedom of speech and expression. When we talk about the speech is normal, but the term expression, that is that is a very broad term. This expression term is a very broad term, and it is so broad so as to cover many things which are of communicative value. And hence you see that this Article 19(1)(a) has been expanded by the judicial interpretation so as to include many other rights. For example, if we see right to know, right to information, these are the parts of Article 19(1)(a). To the extent that the Supreme Court in 2014, this NALSA judgment, which is related to the LGBT rights, the Supreme Court has said that this freedom of expression includes the choice of dressing, even that what dress a person wants to wear, that is a part of Article 19(1)(a) under the term expression. So this is how the creative interpretation can be made. So the first, when the term is so broad and which is giving you the area that you can interpret it very loosely, and here the expression term has been used like that. And the second point is that if the provision is not broadly worded, but it usually adopts the technique of including the concomitant rights, that is the rights which are necessary for making that expressly guaranteed rights, which is to be meaningful and effective. And the Supreme Court has, I mean, extensively used this technique in its interpretation of right to life, which is guaranteed under Article 21. You see that the expansion of Article 21, it is just 18 words article, that no person shall be deprived of his life and personal liberty except according to procedure established by law. So there are only 18 words in Article 21. But you see that this 18 words in Article 21 have emerged out in more than 21 rights. There are so many rights which are the part of Article 21 as life and personal liberty. It started from the very beginning that procedure established law, it has come to the due process of law. In Maneka Gandhi, from A.K. Gopalan to Maneka Gandhi, it has emerged into the due process of law. And once it has become the due process of law, then you see that how, I mean, broadly the Supreme Court has interpreted this Article 21 in terms of the due process of law. So it has expanded the term life, it has expanded the term personal liberty in various cases, rights of the women, rights of the children, rights of the prisoner, environmental rights, other group rights, various rights were the part of Article 21. And as I told you that they have taken the eligible list from the directive principles of the state policy. That simply means that there were provisions in the directive principles, and the Supreme Court has read those principles along with the fundamental rights under 21, and it has created so many rights to the person concerned, and not only to the life and personal liberty of the person concerned, but at the same time now you see that some of the high courts, and particularly I will take the example of the Uttarakhand High Court itself, along with the Punjab and Haryana High Court, when they have interpreted the term person even, so as to include the animals, birds, rivers, all flora, fauna, that has become the part of Article 21. Though it is further, we'll be discussing on that point. So you see that this Article 21, that is expanded in such a way by the judicial creativity, by the activist approach of the judiciary. So while enacting these fundamental rights, the founding fathers, they show that they had the will, and they were ready to adopt the means to confer the legally enforceable fundamental rights. So there were two questions before them. First, against whom were the fundamental rights to be enforced? And the second question was that what activity these fundamental rights enforceable? So the question one that was there in the drafting committee, that was fundamental rights are to be enforced against whom. So broadly speaking, everybody knows that these are the rights which are directed against the state, and it is the state which is defined under Article 12 of the Constitution. It is not the state as it is ordinarily known, that it is having certain territory and there must be a government, that government must working for the persons who are living in that particular territory. No, that is not the state politically speaking. Legally speaking, here these fundamental rights are available against the state, and state is widely defined under Article 12 of the Constitution, so as to include the government of India, the Parliament of India, the government of each of the states, the legislature of each of the states, the local authorities, as well as the other bodies, other authorities within the territory of India and under the control of government of India. This is what Article 12 speaks about. And when we see the interpretation of this Article 12, so there was no confusion up to a local authority, the Parliament, the government of India, the state legislatures, as well as the state state governments and the local authority, they all have been defined clearly. Though local authority is not defined in the Constitution of India, but that local authority is defined in the General Clauses Act of 1897 under Section 3, subclause 31. So the point for elaboration, interpretation, construction under Article 12 to give the remedy to the persons whose fundamental right is violated, then that other authority has been expansively, interpreted by the Supreme Court. And you see that a lot of cases are there in which the Supreme Court has taken that these instrumentalities, agencies are also the part of the other authority, and they will be stayed within the meaning of Article 12. So Ajay Hasia, Khalid Mujib case, R.D. Shetty versus International Airport Authority case, these are some of the cases which are very, very important. Pradeep Kumar Bishwas case. So these are the cases under Article 12. Everybody will be having a look on these cases. I'm not going into detail of those cases, but for the purpose of knowing that the fundamental rights are enforceable. So the question that against whom it can be enforced, the simple answer was that it will be enforced against the state. So you see, as I told you, that ours is an eclectic constitution, and there were no provision in the other constitutions regarding the term state. And this state has been defined in the Constitution of India, and this is known as the original constitution, original contribution of the founding fathers or the authors of the Constitution, because this was firstly created by K.M. Munshi ji. Later on, it was debated, and finally you see that Article 12 is there. And this is another point to be for your knowledge, that state is not only defined under Article 12, but there are other places, other provisions, other articles also where you find that the state is defined. For example, Article 36 is there. So Article 36 and Article 12, these two are almost similar. But Article 1, the state is having a different meaning. Article 308, state has a different meaning. Article 152, state has a different meaning. In Schedule 1, state is a different meaning. But for the purpose of fundamental rights, you see that Article 12 is having Parliament, Government of India, state legislature, state government, local authority, other authorities. So the rights, fundamental rights, if there is any violation, infringement, interference in the fundamental right, one can directly approach to the court of law. Now, the second question was that what activities these fundamental rights are enforceable, against what activities? When one will say that the fundamental rights have been infringed or fundamental rights are to be enforceable. So they were enforceable against the laws. If there is any law which is violative of the fundamental rights, then it can be enforceable against that particular law. And secondly, it is also enforceable against the executive actions. So when at the time of implementation, when the making of the rules, when the making of the regulations, you see, then it can be enforced against the executive action also, because it is being violated the fundamental rights, and you see, in contravening the fundamental rights or violating the fundamental rights, the action can be taken. Because there is another provision in the Constitution itself, that is under Article 13 of the Constitution. Because Article 13, that speaks of the law, that defines the law, and that specifically makes an obligation on the state, that the state shall not make any law which is inconsistent or in contravention of Part 3rd of the Constitution. And you all know that Part 3rd of the Constitution is consisting of the fundamental rights. So if any law is made that is violative, that is inconsistent, that is in contravention, that is contradictory to the fundamental rights, that would be void, that would not have any constitutionality. So the action against which, or the activities against which the rights are enforceable. So this was the second answer of the founding fathers while writing for the fundamental rights chapter. That's why we see that when we start with the fundamental rights chapter, that part 3rd, then it starts with Article 12. And this must be a question to the minds of the students, that what type of the fundamental rights these Article 12 and Article 13 gives to a citizen, to the person. Because Article 12 speaks about a state. State is not a fundamental right. Article 13 speaks about the law. That is not a fundamental right. But these are the very important requirement to put in Part 3rd, because of these two questions, that against whom it would be enforced and for what activities it would be enforced. So the activities, that is the laws, as I told you, that any law which is in contravention of part third, that is fundamental rights, would be void. And second thing, that if there is an executive action, that again it would be violative of the fundamental rights and can be enforced against that action. So Article 13, that defines law, that includes within the definition of law not only the act and statute, but rules, regulations, bylaws, notifications, everything. That means we are having in a country which has accepted for the welfare concept of the state, and in that way we see that more and more powers have been delegated to the administration. All the laws are not being made by the parliament or the state legislatures, but executives are also making rules and regulations. So those rules and regulations are also defined as law under Article 13, and that also has not to be violative or in contradiction or in contravention or inconsistent with part third of the constitution. So these were the two reasons for putting Article 12 and 13 in the chapter or in the part of fundamental rights. Then we see that there are certain questions or certain points regarding the fundamental rights. For example, whether these fundamental rights can be suspended. Can there be any suspension of the fundamental rights? Because these are those rights, as I told you, are in the category of the inalienability rights, or these are considered to be the human rights, because when we see the UDHR, then we see that all the civil and political rights that are the part of the human rights document of 1948, those are incorporated in part third of the constitution. So whether these fundamental rights can be suspended? Yes. When we see prior to 44th amendment, then we find that the fundamental rights can be suspended. It was suspended earlier. And there was very infamous case of ADM Jabalpur versus Shivakant Shukla of 1976. You see that the emergency of 1975, that during this emergency of 1975, this case is also known as the habeas corpus case. And in that habeas corpus case of ADM Jabalpur, the majority, the court said that this Article 21, right to life and personal liberty, is the sole repository under Article 21, and it can be suspended. But the dissenting view of Justice Khanna, that was very important for the purpose of this liberty, freedom, and right to life and personal liberty. When he said that this 21 has not conferred upon a person the right to life and personal liberty, because ours is a constitution which was enforced in 1950. So this 1950 constitution is conferring this right to life and personal liberty. The persons were having these rights when they got births in the society, and this is not something which the constitution is conferring upon you. And you see that this dissenting opinion of Justice Khanna has become the majority opinion in 2006 in M. Nagaraj versus Union of India, when the court by majority, that was unanimous, they said that these fundamental rights are the limitations on the power of the government. These fundamental rights, human rights, are the limitations and prohibitions on the state action. And these are available to every human being by virtue of being born in the human race. So this was the decision of Justice Khanna in ADM Jabalpur case, which became the majority judgment in this M. Nagaraj case in 2006. So after 1976, 2006, this was the time. But in between, when I'm talking about the suspension of right, then the fundamental rights were amended, and by 44th amendment, and at the same time these rights, particularly Article 20 and 21, cannot be suspended even if there is emergency, because during emergency or proclamation of emergency under Article 352, on the grounds of the war and external aggression, these rights could be suspended. But after 44th amendment 1978, now the rights cannot be suspended, and there would be a special notification by the President of India for the suspension of the other rights, not 20 and 21. Then we see that whether this fundamental rights, this ADM Jabalpur case, that was the case which was said to be one of the dark blot in the judicial history, or Sirvai, who has written a very good commentary on the Constitution of India, that is an authority in itself. So he was of the opinion that this judgment in ADM Jabalpur case, which is also known as the habeas corpus case, that is something like a self-inflicted wound by the Supreme Court on itself. So this is how we see that so far as the suspension of the fundamental rights are concerned, it is not to be suspended, and after 44th amendment the situation has been changed. Now regarding the classification of fundamental rights, because as I told you, article 12 to 35, there are various types of the fundamental rights under part 3rd given to the person or to the citizens concerned. So now we are having 6 rights in the constitution part 3rd. So everybody must be aware, you are all the students of law, that right to equality is there, right to freedom is there, then after that right against exploitation is there, then freedom of religion is freedom of religion, right to freedom of religion is there, then minorities rights are there, and the very importantly right to move to the court, that is right to constitutional remedy, which is very unique right, that is also the part of the fundamental rights which is available to the person concerned. So this is one thing, that when we talk about the classification of the rights of these 6 type of the rights, but these 6 rights are not available to all the persons. Some of the rights are available to the citizens, some of the rights are available to the person. A person can be a citizen can be a person, but a person cannot be a citizen in all the cases, because you must be aware that the legal personality is being conferred upon, and the persons are the judicial persons. So you see that the rights which are available to the citizens, for example under article 15, 16, 19, 29 and 30, these are the rights which are available to the citizens. If we talk about the article 19, which says that freedom of speech and expression, so this right cannot be made available to a person, because if it's a judicial person, if it's a legal person, then how come this right can be exercised by a legal person, right to speech and expression? So you see that the rights which are available to the citizens, simply then article 15 and 16, which speaks about the employment in the public services and the services under the state, or article 15, which confers upon certain reservations or certain positive actions for the society, in the backward class in the society. So you see that these are the rights which are available to the citizen, while there are certain rights which are available to the person. For example, article 14, which speaks about the right to equality in general, that says that the freedom of equality, that is equality before the law and equal protection of the laws. Then article 20, article 21, when we talk about the article 21, then we see that the citizens, persons, at the same time the non-citizens also. So this is a right which is available to the person. And there was a very important case of Chandramada. She was a Dhaka national, and the court has given the compensation of rupees 10 lakh in case of some rape and molestation in some railway station in Calcutta. So that is the right which is not available to the Indians, that is available to the non-citizens also. So we see that the rights which are available to the persons, they are article 14, article 20, article 21, then article 21A, that is a new insertion, incorporation by 86th amendment to the constitution, which speaks of right to education. So it's available to the person, but you see that it speaks of 6 to 14 years of age. So the person, these children, they are having this right under article 21A. 23, that is trafficking, and begar, etc., that is human trafficking, that is the right under 23, and 24, that prohibits the child labor. 25 to 28, that is for the religious rights. So these are the rights which are available to the person and the citizen. So the first classification is regarding the applicability of these rights, that is these rights are available, some of the rights are available to the citizens, and some of the rights are available to the person. Then regarding negative and positive rights, these fundamental rights are further termed as. In some of the books, you'll be finding that these are also written as the negative rights and the positive rights. So they are not negative and positive rights as such, but the wordings which are there in the Constitution of India, that speaks about something like that. It is negatively termed, it is positively termed. For example, If you see Article 15, Article 16 too, then it simply says that a state shall not deny, the state shall not discriminate. Article 21, that the no person shall be deprived. So when it starts with the negative terms, so these are termed as the negative right. But there are the positive rights also. For example, Article 21A, as I told you, it's an education, right to education, and the right to education is to be made available to all the children from the age of 6 to 14 years. So 29, 30, and 32, which speaks of the constitutional remedy. So these are the rights which are available to every person concerned, and these are termed as the positive rights. Then you see there are certain group rights also, that right which cannot be made available to the single citizen, single person. These are said to be the group rights. You see that Article 15.3. Article 15.3 is a special provision. That is an obligation on the state to make rules for the women and the children. So women and the children, they make a group. Similarly, 15.4, 15.5, 15.6, these are the provisions which speaks about the making of the special provisions for the backward class of the person, the society, specifically SC, ST. Then 15.5 speaks about the admission in the central academic institution, and very latestly incorporated 15.6, that is for the EWS, that is economically weaker section of the society. So these are the rights which are known as the group rights, which are available in the group. Article 26, that it speaks of the religious denominations. So that's not the right of a single person. So group rights are there. Then there are certain rights which are an absolute rights, and certain rights which are having certain restrictions also. As I told you that in American Constitution, these rights are having no restrictions, but in India, we are having the rights which are having certain qualifications, certain restriction itself, and that is not open for the judicial interpretation. That is the part of the written constitution. For example, if you see that rights which are not having any restriction, that is Article 17, there is no restriction. Article 18, there is no restriction. Article 17, that speaks about the abolition of untouchability. Then Article 18, that speaks about the prohibition or the awards and titles, etc. Then Article 20, 24, there is no restriction as such. But there are certain articles which are also having certain restrictions. For example, Article 19. If we see the freedoms under Article 19, then we find that each freedom is subject to certain reasonable restrictions. Article 19.2, 19.3, 19.4, 5, 19.6, all these are what? These are the reasonable restrictions. So the citizen is not free to enjoy that right or that freedom in an absolute manner. Certain restrictions are also imposed over those rights. Then another type of the classification which we find in the books, that is rights which are self-executory, and rights which need no legislation. When we say that it is self-executory, that means the provision which is there in the Constitution of India, that is applicable as it is. For example, we talk about Article 14, equality law, equality before the law, that has to be applicable. Right to life under 21, then 19 freedoms, no specific legislation is required. They are self-executory. But there are certain rights which needs a legislation for its implementation. And these are, for example, Article 21A, which speaks of right to education. So for that, a special law is required. Similarly, Article 15, Clause 5, a law is required for giving admission in the central administrative academic institutions. Article 17, the law is required. So you see that there are certain laws which are self-executory. There are certain laws which need a special legislation for making them implementable. Then as I told you that these are the rights which are available or which are directed against the state, and some of the rights are also available against the private individuals. And these are very specific and very important rights. For example, Article 17, which speaks about the abolition of untouchability. That is a fundamental right which can be made available against the private individual also. Similarly, 15.2, which speaks of the access to and use of certain public properties, public roads, public places, etc. that can also be used against the private individual. So we see that the fundamental rights in India, they have been, placed on a very, very high pedestal by virtue of Article 13, because Article 13 is the power of the court to review as to a law or the executive action. If it is violative of the fundamental rights, then that would be declared unconstitutional. So fundamental rights have been placed on the very high pedestal by virtue of Article 13. This is one thing. The second thing which is emerging out of this discussion is that the Constitution of India not only guarantees the fundamental rights, but it also guarantees the remedy for the violation of these rights, which is a unique provision in the Constitution of India, that is guaranteed by Article 32 of the Constitution. And you see, that is the constitutional remedies. So we see that these rights are directed against the state, and it makes the Supreme Court the guardian and the protector of the fundamental rights. So in that historical perspective, we see the rights which have been emerging to this constitution. That was the requirement of the time when the constitution was being drafted, because Indians were in the slavery of the Britishers, we all know. And at that time, this liberty was very much required, the rights were very much required, and that's why we see that the first draft which was produced and which was brought before the Constituent Assembly, and that was consisting of all those rights which now we are having in two parts of the Constitution, one as the fundamental rights part 3rd, and the other as the directive principles of the state policy in part 4. So when all these rights were brought, and at the time of the debate, it was debated that India is not in a position to confer all these rights enforceability and justiciability. And then the subcommittee on the fundamental rights had bifurcated these rights, and it again brought that rights which are justiciable and rights which are non-justiciable. So you see that at the final stage, this non-justiciable rights became the directive principles, and justiciable rights became the fundamental rights. So with these words, I would be happy if there are any questions, because I'm not dealing with the case law, because if I'll start to talk about the case law, then there would be no end of any lecture. Everybody must be aware about that. So with these words, thank you very much.
Thank you so much, ma'am. On